is the future of all things legal law in an age of fast-changing and increasingly disruptive technologies. And we spotlight this these many dimensions. We're really pleased to have two friends and now colleagues here to give us a taste for this space. Give 10 down, faculty member of Suffolk University, law school, but is here as a faculty member. It's coming to see. And we'll spend a big chunk of his professional time engaging in the world of technology and law. The entrepreneurial side of that, thinking about new usage cases, the role of the classic legal system, all the rules and regulations that apply to these new domains. He'll cover big territory there, but give you all a taste for what's upcoming and imminent in this domain. Second, Dazra Greenwood, who runs the law that new effort here in the Media Lab as a visiting scholar and colleague in thinking about the role of especially emerging the domain of blockchain plus in how it can rechange or reshape how we interact with one another through commerce, as individuals, etc. And he'll spotlight especially the emerging technology domain. As you can see, he is aficionado testing out the latest stuff on us. So with that, this is a great topic. Right? This is rich territory, a lot of stuff, and has implications for many ventures and sister sectors. I wore a ginger shirt today to salute another super theme, which is technology and mobiles meets health. This is a company born from this class where Sloane, or I'm saying Matt, Media Lab student, Momada, and they said, wait, can we use mobiles to really reimagine how we measure healthcare? Well, our personal health status. Well, that is what we hope will happen with a little bit of provocation from these two visitors today. Maybe today will get you to be thinking about what's your next venture. Perhaps it too will touch on all things law. Gabe, take it away.
Thank you. Well, thank you, Yost, and thanks all for making me feel welcome. So I'm a person that comes from two worlds. I've been over at Suffolk as a member of the faculty for the past 10 years. And I've been studying the technology of law as opposed to the law of technology, which is the thing too. I'm not interested in patents and IP. What I'm interested in is how to make the delivery of legal services more efficient, more effective. So I've been at this 10 years, and this is longer, frankly, than just about anyone. But at the same time, I started at Suffolk the same year the iPhone was invented. So the fact that I've been at it a long time relative to others doesn't really mean much because the technology has changed so fast that it's a series of sort of changes that are just starting to happen. So it's about 10:15 now. Courthouses in the Commonwealth of Massachusetts, bailiffs are emerging from the judge's chambers, and they're summoning everyone to court using a statement, "Oh yea, oh yea, oh yea. All ye having business before this court, draw near, and ye shall be heard. God save the Commonwealth." We've been uttering that since before there was the United States, and we borrowed it from England, which has been uttering it since the Magna Carta. But it's still existing in Massachusetts and in other places. There are lawyers that are harnessing technology. We think they're just hard on that. Example. The growth of electronic discovery, litigation, lawyers have to change each other, Coke to Pepsi or trademark. There are going to be millions and millions of pages of paper reviewed by lawyers at $500,000, $700,000 an hour before one of their clients switch the papers to their opponent. Well, historically, that's taken human lawyers days, months, and years to actually accomplish. Now we can load it up at the discovery software, and not only can we recognize specific terms that we're looking for, using rudimentary AI, we can discover context-based themes. So in other words, we don't have to worry so much about just looking for the word lawyer. We can find within those gazillion documents references sort of legal that don't necessarily mention the lawyer. All because we have available, and it's totally changing the way the legal market works. So I spend a lot of time talking to legal professionals about being innovators and making changes. And one of the things I like to do is to help people find role models that help them track and say, I'm going to be like that person. That's going to be my Thomas Edison. The challenge is there really aren't any of those people in legal. The which is one of the reasons I'm excited to talk to you guys, because maybe one of you or many of you will be those people. So what I do is I start off by telling lawyers the story of one of my innovation heroes, Takeru Kobayashi. Now, Kobayashi came to the US in 2001. He worked in a very heavily regulated field. And because he was willing to look at the rules a little bit differently, he was absolutely able to revolutionize the way that things happen. He is a true innovator in the most important sense. He is the all-time hot dog eating champion. And he didn't just break the record, he crushed the record. So before Kobayashi, the most that anyone had ever eaten is 23 hot dogs in 12 minutes. This is at the big annual Coney Island thing. But Kobayashi read the rules, and what he discovered is that the rules allowed him to bring water in. And not only could he bring water in, but he could take the hot dog apart, and he could dunk his bun, and while the bun was soaking, he could mount on the hot dog, and then he could eat the bun, which no longer had air pockets in it, and he could eat much, much, much faster. So by the time Kobayashi got done, he had more than doubled the previous record. He ate 50 hot dogs in 12 minutes, and he's continued to build on that. So if there's any sort of take home today, it's that your hero should be a person like Kobayashi, a person that read the rules closely and said there's an opportunity here to do something a little bit different and just make value where no value had been realized before. But the legal vertical doesn't make that easy. Laws of guilt is intended to keep people like you out, unless some of you people have law degrees, in which case, welcome, as long as you figured out. There are a few different barriers that are legal, and there's some cultural barriers too. The legal barriers. A person who is not authorized may not practice law. The practice of law is hard to define, but generally it's giving legal advice that would take some sort of expertise. Unauthorized is a euphemism. It's a crime. You go to jail for it. They'll put cuffs on you and throw you in jail if you practice law without a license. So for an entrepreneur, it's a disincentive to say, I'm going to do something that looks like practicing law, because you might end up with problems. Challenge number 2, intended to keep people like you out. Every jurisdiction in the United States licenses lawyers separately, and there's not necessarily reciprocity. I graduated from law school. I took the Massachusetts bar. I am authorized to practice law in Massachusetts as long as I pay my dues and remain in good standing. If I try to do that in Rhode Island, I go to jail. Okay? So even within the scope of the practice of law, there are monopolies within specific jurisdictions. So that's a significant challenge that people need to be aware of. Third, if a legal partnership, a law firm, is going to try to innovate, they have to be able to generate the finances to do it themselves. Or they have to get someone to do it who doesn't want to take equity. Why? Non-lawyers cannot own law firms. Okay? If you are not a lawyer, you can't be a partner in a law firm that takes equity. Now, this is actually a real challenge for people that graduate from MIT and want to work in the patent field but haven't gotten a law degree. A high-paying job is a good job where they use their science background. They can never become partners in a law firm. It is illegal for people who aren't partners in a law firm to own equity in it. Well, that's a challenge because it makes it so that venture capital can't be brought in, right? You can't have the opportunity to fully grow out in a way that other industries can. There are also a couple of cultural challenges. One, law firms tend to bill hourly. That means there's a disincentive to being efficient. You with me on that? If you can make $1,000 an hour and you can bill 100 hours, why do it in 50 hours? And this consistently is a problem. And in areas where they don't bill hourly, they tend to become much more efficient. Finally, when partners in law firms leave the firm, their equity stays behind. So if an aging lawyer says that's enough, I'm going to go to Nantucket, I don't want to do this law thing anymore, I'm no longer in the active practice of law, the shares they have in the profits that that firm makes stay. They get redivided. I get redivided among their former colleagues, which means that senior partners in a law firm have a disincentive to invest long-term in the health of the law firm. If you're 70 years old, you've got 2 more years in you, and someone who's lower in their career trajectory comes to you and says, look, we can spend $10 million, we can build this technology, it'll make our firm healthier, we'll be better representing clients. You say, well, wait a minute, I'm never going to make my money back on that investment. No, right? No. So there are all these disincentives in place. Having said that, there's still opportunities, and there are opportunities that are still a little bit at the edges. But here's where I really see a chance for folks like you to get involved. Legal tech startups. The idea of building a company that serves the legal vertical in a model that isn't a law firm. Since 2012, there's been about $750 million of venture capital money that's come into the space. Almost all of the companies involved in it are doing something that serves the existing legal community. They're B2B businesses. They're going out and they're trying to sell a piece of software to a law firm or a law department. And the law department is the lawyers who work for a private company, who incidentally have a different set of incentives. They don't go by the hour. They're just trying to get the work done for their company. Legal tech startups go out and they sell products to those entities so that they can be more efficient and effective in the work. And there's some real money coming into this space. Again, the biggest year was $458 million, but the total for the last 5 or so years has been $750 million. The big firms are looking into putting money into it. Bessemer has major investments out there, and others in the Silicon Valley community.
Can you just give us a taste of what some of these segments are?
Yeah. So, law practice management is the challenge of lawyers who deal with many millions of pieces of paper within their firm, being able to keep all those pieces of paper together, organized, keep themselves calendared, be able to share information with others, be able to create a knowledge bank so that they can not have to reinvent the wheel every time. Legal research is the work that workaday lawyers do when they're trying to solve a legal problem on behalf of a client that requires the application of legal precedent. And many legal research companies go out there and they try to find a more efficient, more effective way to help lawyers get the answers more accurately and more quickly. Ediscovery is the challenge that I introduced at the beginning of the talk, involving litigation, where the sides have to exchange massive troves of information to each other. And a lawyer has to put eyes on that piece of paper to make sure that what they're giving is permissible, that they aren't doing things that are confidential or that the law requires them to hold back to their client. So there are a number of companies that have adopted new sorts of technologies that seek to make that project more efficient. Online dispute resolution is fascinating. The biggest online dispute resolution company in the world is eBay. They do millions and millions of deals every year. Rather than go through the traditional court system or even something less formal like local arbitration, a law office, you do everything online. There's a very well set up set of rules for how to deal with disputes on eBay, and there are a number of companies that try to work in this space. There's the legal education startups, and in fact, one with the orange boxes company I own called Space Repetition Systems, and that company does algorithmic learning for law students. It helps law students prepare for the bar at a much more efficient rate. And while I'm very proud of my company, it says something about the sort of map of where the legal tech startup world is, because it is a company with one employee, me, and while we're growing by leaps and bounds, we're still very much a 5-figure a year company. Yet we still make it onto this sort of paperwork. So that's a general overview, and I'm going to go through some of the specifics, Joseph, if that's cool, because I want to get into some really neat examples. So most of those that I just showed you were B2B. They try to service law firms. They try to service corporate legal departments. There's one company that's really made a difference trying to go directly to consumers. And this is something that I think is probably the most interesting opportunity for entrepreneurs to get involved with law. LegalZoom is a legal document service. If you need a will, rather than go to a traditional lawyer working in a traditional brick-and-mortar law firm, you can go online to LegalZoom. You tell the website what jurisdiction you live in, and it asks you a series of questions about your needs, and then it takes data that you input into it and it places it into the right place in a will form, a legally enforceable will form. It then tells you what you need to do to make it so that it'll be enforceable after you pass away. Now, the interesting thing here is, rather than cost, say, $5,000 to have a will created, LegalZoom can do it for $500. And the statistics demonstrate that LegalZoom wills are enforced at about the same rate as any other will. In other words, you save $4,500 and you have about the same percentage chance of having success if someone debates whether your will is valid. LegalZoom's been quite successful. It's hard to tell exactly how successful. They're still a private company. In 2012, they made motions like they were going to IPO. They subsequently withdrew it, but they had to file a S1 form, the form that discloses what they've been up to. They made something like, and this is the most recent public data, they made $156 million revenue in 2011, and the 2 years before that, they had made over 100 million both years as well. And they had some interesting sort of data points that they were able to point to. They helped, as of 2012, this is the most recent sort of reputable data. They've helped over 2 million people. 20% of companies that are formed in California are formed as a result of legal Zoom deals. So LegalZoom is like a really interesting company, and it's also probably the one really, really solid example of a legal tech startup that's come out and designed to aid consumers and to close the access to justice gap. More on that later, but relates to the idea that regular people often can't afford legal services and they need opportunities to do that. And they've been largely successful. Now, there's a challenge that LegalZoom's faced that we should also just briefly touch on. LegalZoom is doing something that looks very much like the practice of law. I told you early on that that's a crime. You can't practice law unless you're a licensed person. So when LegalZoom asks you a series of questions, it's making decisions behind the scene using an expert system to help you figure out what form should be used for your will. It's doing the kind of work a lawyer would usually do. So LegalZoom has been sued in all 50 states, and the state's attorneys general, when they show up in the state, will say, wait a minute, what you're doing is practicing law LegalZoom. That's illegal, that's a crime, you can't do it, you have to stop, here's a cease and desist order. And LegalZoom has fought it in all 50 states. And in every single situation, they've reached what's called a assent decree, which is they have agreed with the local attorney general that they're going to settle it. And the way that they've typically settled it is by saying that they'll disclose on the site that they're not lawyers and they don't pretend to be lawyers, and that they recommend that people with any questions go seek a local lawyer, which makes the local attorney general happy because they're protecting the monopoly of local lawyers, right? But there are funny sort of issues that arise with this. So I was at dinner with the general counsel of LegalZoom a couple of years ago. One of my favorite questions to ask entrepreneurs is, if we woke up in 5 years and discovered your company didn't exist anymore, what would be the reason? And he said, well, we'd be regulated. If they regulate us, we're dead. I said, well, help me unpack that. And I realized, and stupid me for not realizing, so as a lawyer, when I practiced law, I was licensed. I'd gone to law school. I graduated law school. I passed the bar. And then from there, I carried malpractice insurance. If I made a mistake in your case and you would have gotten $1 million, but for my error, you would have recovered. My insurance would have paid you $1 million. So LegalZoom, which is doing what to me looks a lot like law, doesn't have any of those things. They're not licensed. It's a computer, right? And beyond that, not only, incidentally, lawyers can't prospectively limit liability. In other words, you can't take on a client and say, if this goes bust, you can't sue me. Lawyers may not do that. That's against the ethical rules of each part of doing it. LegalZoom, on the other hand, at the outset, makes you sign an arbitration agreement. And they say, no matter what happens, you can't sue us in court. That means we'll never go public. No matter what happens, we'll never go public. And then beyond that, they say, no matter what happens, we have to have a limit on the liability that we have to pay. It's $500. So if you're a tightwad who's really rich, rather than going to a lawyer and spending $5,000 on a will, you do the $500 deal. And they screwed up, and your money goes to the wrong person, and the right person sues. The person or the entity they sue is LegalZoom, and rather than being entitled to being made whole, many millions of dollars, they'd be entitled to $500 arbitration. So when this general counsel said the problem that would kill us is regulation, what he meant was, if you go buy insurance and be responsible if something goes wrong, that's going to be really bad for business. So there are interesting challenges in this sector. Now let me talk a little bit about what's happening among the law firms and the law departments, because there are some internal players trying to do cool stuff. Goodwin Procter, national law firm, but it's centered locally. It's been around for more than 100 years. And they have a really well-respected startup practice. And one of the things they try to do is get new companies open, Delaware LLC or whatever is the correct corporate entity, and then to help them get off the ground. And for years and years, they've done that, but really they've had a tough time collecting money for it. You can't charge a new company $25,000 when they don't have any VC money, because they need to become a company so that they get VC money. It's a chicken and egg problem. So in 08, 09, when the economic downturn happened, they had a whole bunch of partners who had nothing to do with their time. They had no one to deal because there were no deals happening. So what they did was they said, well, why don't we automate this? Why don't we build a LegalZoom for startups?
so that they can come to us and we will help them get started. Questions on our website will then generate automated forms and tell them how to file the form so that they can get incorporated in Delaware. They get nothing directly in exchange except for a contact and goodwill. So they send their quarterly newsletter. And the theory behind Founders Workbench at Goodwin's Proctor is that in 10 years, some of these companies are going to get big. They're going to IPO and they're going to need someone to do the IPO for them. That's $1 million worth of business right there. They want to be the people doing it, and they're giving away Founders Workbench for free.
Are they taking an equity stake at that moment?
Don't take an equity stake at all. They don't. That's not part of the ask. It is a legitimately free service. There is a firm, incidentally, called Denton's, and they have a group called Next Law Lab that is treating legal service provision like a piece of a incubator. So they'll incorporate you. They'll give you advice on how to get off the ground, both legally and in terms of business, but they get a stake for it. The fellow you see in the upper left is named Zev Eigen. Zev works for Littler Mendelsohn. He's actually a Sloan graduate. He has a PhD. I couldn't tell you the subfield. And he went to work for this national firm called Littler. And the work they do is focused in labor and employment law. And what Littler realized was that their business wasn't where they wanted it to be. And that for them to scale would require them to hire more and more lawyers, because if you're billing hours, there are only so many hours that a human can do, about 2,000 a year is maximum for a big lawyer to do. And they decided it's just not an investment that they were comfortable with to scale. So they said, let's try something different. Let's try creating different streams of revenue. So with Zev, who's a data scientist, they said, well, what if we ask our clients, who are largely in the labor and employment field, to share some data with us, to share information about their practices and policy, share HR information. And in addition to giving them advice when someone gets fired or when they have an accusation against them for equal employment opportunity discrimination, let's start to prospectively give them business intelligence about human resource decisions using big data. So, for example, they'll look at a company's hiring practices, and they'll look at the demographics of the people they're hiring and say, we think your numbers are actually a little bit off. You're not hiring an appropriate number of people of this demographic group to avoid being sued. We have this giant data set, and we can see that there's a problem headed your way. Or they'll look at a giant national company with thousands and thousands of employees, and they'll say, at this specific division over here, you have one specific group where women aren't being promoted at what we consider to be a typical rate. And of course, it's just data. It's not a truth existing on the ground. But what they do is they provide intelligence to their clients to say, hey, here's a red flag. You should go look into this thing because our experience shows that this is potentially a problem coming your way. So Littler has successfully gone from a law firm that just provides legal services to a law firm that provides legal services, as well as using the intelligence they gather from their clients to provide advisory services.
So this strikes me as analogous to the world of health, where typically the system is paid for reacting to a thing that is real versus preventing something that might happen. And the compensation for reaction is obvious. The compensation for prevention is fuzzy.
Yeah.
Surely this has analogous pitfalls.
Yeah, absolutely. So they do two things with this to deal with that problem. One is they use it as a way to induce new clients to come aboard. They say, look, if you IBM have 10,000 billable hours that you'll give us a retainer for this year, because that's the kind of scope they deal with, we will provide this service for you for free for that year. And then alternatively, they just go out and they sell the service at like a monthly subscription rate. For X number of dollars a month, we'll provide this intelligence service to you separate and aside from whether we represent you. So I don't usually talk about two-person boutique law firms in Texas, but this is one that is worth talking about. So the fella on the right, Kiwi Kamara, is the youngest ever Harvard Law graduate. He graduated from Harvard Law when he was 20. And he has this IP firm in Houston, I think it is. And what they discovered was that none of the software solutions that they were using for patent and trademark search, which is to say a client would come to them and say, the have to figure out if someone else already had this idea and has reserved the monopoly with it for the government. None of the software that they were using was for their liking. They figured that everything they had to do was just inefficient. They didn't like it, and it was just causing them more problems than it was worth. So the firm went out and they raised $2 million, and they built their own software system to solve the problem. And it's called CS Disco. And CS Disco is now employed at about 150 of the AmLaw 200 law firms, which is the 200 biggest law firms in the United States. And they have since, the revenue simply by running the software company as a side hustle to the practice of law has become the driver of their business. They make many multiples on the software development as they do actually representing clients on a one-to-one basis. And there's been an interesting move among law firms to think seriously about purchasing software for the purpose of reselling, whether it's to other law firms or to their clients, sort of in the vein of Whitler Mendelson with their big data. There have been other firms that have gotten interested in existing in the space. One of the examples of one that just fell apart at the last minute is a company called Lex Machina, and Lex Machina uses business data analytics to predict what's going to happen in certain forms of litigation, mostly patent litigation. So if you have a company that's about to go into a lawsuit and you know the jurisdiction where the case has been filed and you know who the attorney is on the other side, they can provide you with information about your likelihood of success and the timeline involved and help make valuable risk management decisions. So Lex Machina very, very nearly was acquired by a New York law firm called Jackson Lewis. At the last minute, LexisNexis, which is a research company, came in and media company swooped in and purchased them for $30 or $35 million. I don't remember what the exact figure was. But law firms are now interested in buying this sort of stuff. The idea being they can use the tool themselves, but also they can sell the tool to others and make it available for their clients. So Kamara and Sibley is the firm that has successfully done this, even though it's sort of a modest-sized firm in a far-off place. All right, so I somehow lost some of my slides on this one, but let me just tell you briefly about what's happening in corporate law departments. So corporate law departments have a different incentive from law firms. Again, law firms tend to bill by the hour, disincentive to efficiency. You want to bill as many hours as you can because that's the only way you get paid. So you want to bill as many hours as you can without your clients firing. Corporate law departments, their sole job is to be efficient on behalf of the company. So Verizon has 4 different divisions. The most interesting one to me is called Enterprise Services. Enterprise Services is the part of Verizon that sells Verizon services to big companies. So if, say, Best Buy says, look, we want to wire up all of our retail locations with Verizon services so there's great Wi-Fi in the store and our cell phones work, they make a deal with Enterprise Services. And they have thousands and thousands and thousands of these contracts. But they're big, right? So they have a volume business, but they're for millions and millions of dollars a year. So Verizon said, we need to be more efficient in our contract cycle. Someone says, we want to make a deal with you. There's 7 different entities within our Verizon that need to sign off on it, and it's taking 60 days, and that's lost money. So if we can shorten that cycle from 60 days to 50 days or 40 days, that means more money in our pockets more quickly and more interest on these huge strokes of money. So the way they decided to solve that was by calling an all-hands-on-deck hackathon. And Daza might even talk about it later. It's been one of the sort of leaders in the legal hackathon. The idea is to get all of the folks in the legal department together with other stakeholders, business people, accounting people, clients, and present a problem. In this case, again, the problem was how do we shorten the contract cycle, and to give them a couple of days to focus only on resolving that specific problem. And in Verizon's example, they worked in teams of 5 people across 5 different continents over a 2 or 3 day period. And at the end, they invented 3 solutions, which were totally novel, totally new. There were 3 winning teams. Part of the hackathon concept was that different teams would present their solutions. And each one of them had a business case that would save them in the tens of millions of dollars over the long term. All because they were willing to sort of set aside their legal work for 2 or 3 days and do something different. So when we talk about legal technology, all the things I basically talked about so far are software solutions. But there are innovations that are opportunities too, for people that can come in and say, look, I can help you harness innovations by using engineering processes or using design processes. There's an opportunity to get involved and to make money. So let me tell you about 3 changes that are on the way, right? These are things that are going to be happening in the, say, 2 to 4 year horizon that we need to be aware of. One, corporate legal departments are becoming more educated. So there's one person that sort of embodies this movement. It's the fellow in this picture named Casey Flaherty, and he was the general counsel of Kia Motors. And he found that as he audited the bills for the lawyers he paid to do work on behalf of Kia, he was paying immense amounts of money to associates making $500 an hour. An associate is a relatively new attorney with no equity in the firm, usually with 1 to 7 years of service. He was paying millions and millions of dollars to associates who were working on Friday nights, because you could see that specifically, and spending way too many hours on motions. Motions are legal arguments that you put down in Microsoft Word. Microsoft Word is relevant. He said, I think these guys probably are super inefficient with the tools that they're using. I don't quibble with their legal arguments. What I'm quibbling with is the idea that it's probably taking them 45 minutes or an hour to format this document in a way that a court will accept. Courts are really thinking about the rules, right? And what Casey said was, if you get hired by Kia from here on out, every lawyer who touches this matter has to prove that he or she is competent in basic office technology, Microsoft Word, Excel, PowerPoint, Outlook. And he created a spin-off business that goes out and it tests lawyers on their competence to do basic tasks with Word. And what he found out is that the average lawyer who should have finished one of these tests in a benchmark of 1 hour was taking about 5 hours. They're billing those 5 hours. So that's 4 extra hours at least $500 an hour, times thousands and thousands and thousands of lawyers, simply because we use this tool that's too intuitive for us to realize that we need to be trained in. So the educated corporate law department is a thing. The other aspect of his work is he published what I think of as sort of a tell-all called Unless You Ask. And this is a guidebook for lawyers at big companies to say, you know, you're not squeezing maximum value out of the law firms you hire. There's other things they could be doing for you, and you're just not asking, and you should be asking. Because there's a funny dynamic between lawyers. It's still an old boys club, right? So-and-so is the head of the litigation department at a big firm who went to Yale with so-and-so who is the law department at this company. They're going to have a gentleman's agreement. You give me a fair deal, I'll take care of you. And they're both trying to rip each other off behind the scenes, right? There's very, very little spoken about the relationship and how it should be defined. It's largely dealt with on sort of a gentleman's agreement basis. And the problem is no one's getting very good value. So this book, Unless You Ask, lays out all the things you can ask for that they can easily give you at very little cost to themselves that they should. Example, they can provide a hotline for you because there's always a lawyer at the firm who can help with that. They can provide secondments. They can send someone from their firm over to spend time with your outfit so that they make sure they understand how it works, et cetera, et cetera. So this book is freely available for people in corporate law departments, and the more educated they get, the more opportunity there is for them to make smart decisions. So this is the thing that I think is going to most likely disrupt the way that the work of lawyers specifically works in the next, say, 5 years. The state of Washington has done away with the old rule that only lawyers can practice law. They've replaced it with a narrower rule that says, well, some matters, typically those involving family law, and typically those of less complexity, can now be resolved by people who are called limited license law technicians. And they can actually dispense legal advice within these scopes, right? Sort of like how at CVS you can go and you can see a nurse practitioner if you think you have a flu. That nurse practitioner can do a lot of things. He or she can prescribe you medication, he can give advice on how you should try to recover, and of course, he or she can't do other things. They can't do surgery on you, they can't admit you to a hospital, but there's a narrower scope of things that they do at a significantly lower cost. And when I think about this move to triple LTs, limited license law technicians, I think about the Southwest airline example. So when Herb Kelleher started Southwest in 1969, he wanted to have a national low-cost, efficient airline that was going to provide great service at a better cost. And the FAA boxed him out. He said, no, you can't do it. You got to spend all this money to make sure that your safety is up for regs. And he said, well, wait a minute, no one can ever compete doing that. I can't do that. This is only allowing incumbents in the industry to play in the space. So what Kelleher did was say, fine, You know what I'm gonna do? I'm gonna start a Texas-only airline. It's not federal. FAA doesn't have any rules that apply. It's gonna fly between 3 cities in Texas. And he ran Southwest successfully for several years in Texas only. And he went back and he shared his data with Congress about the safety record of Southwest. Turns out that Southwest was that safer than any of the FAA regulated companies. And what happened? The walls fell down. Fly from Southwest from anywhere to anywhere. The same thing's going to happen with LLP. So as lawyers try to hold on to their monopoly and say, well, we're the ones that hold on to the knowledge. No one else is qualified to do it. I don't think that's really true. And I think the LLTs are sort of the opportunity for people to think about how that changes. What that means is that an innovator who's able to harness paraprofessionals who are qualified to provide unique areas of legal advice is going to be a remarkable advantage when this comes about. So one of the things that's always befuddled me is why law firms don't do a better job of collaborating. Because there's certain things that there's no need to compete on. If you have a billing practice that's really efficient, there's no reason that you shouldn't share it with others in exchange for the idea that they might share something with you later. This is just starting to happen. It happens in industry, and Plant Bottle is the most wonderful example from industry. All these players in the retail industry were getting pressure because they were creating all this plastic that was destroying the environment, expensive, unclean. And what they did was they banded together, Coca-Cola and Heinz and others, and said, well, wait a minute, why don't we just collaborate, come up with a better plastic bottle? And they did. This project called Plant Bottle has saved millions and millions of tons of plastic and billions of tons of waste that go into the atmosphere because companies collaborated that typically would not collaborate. So we're just starting to see this in the legal industry, and there's no organization called CLOC, the Corporate Legal Operations Consortium. And the goal of CLOC is to get lawyers together from different corporate law departments and say, why don't you guys share intelligence? The lawyer at Google is not in competition with the lawyer at IBM, who's not in competition with the lawyer of Coca-Cola. So if you guys are willing to share information on a listserv about, say, how much you would pay a firm for this kind of work, how is that not to everyone's advantage? But there's all sorts of opportunities. So CLOC is the talk of the town in legal. So if you go on sort of any of the legal blogs or follow any of the big legal writers on Twitter, you will see a weekly reference to CLOC. But the interesting thing is CLOC was started as a side gig by a woman named Connie Breton, who is the general counsel of NetX. It's a wonderful project, but no one has taken it to sort of the level of scale that it potentially could be. This idea of collaborating among law firms in a space that historically hasn't been one where collaborations occur. Let me just send you a couple more because I want to turn this over to Daza. There are two things that are going to happen in the longer term that are absolutely going to change things. I'm not quite sure yet because they haven't fully arrived. IBM Watson has a legal department. The legal department is doing something very interesting. So obviously they can take context-based information and they can find it within challenging documents, right? So they could look at a giant trove of documents and be able to find things not just on the words, but on the tone that's used within. You could look through 1 million pages of emails for a company that was being sued for bias, and you could look for racist jokes. And they wouldn't just have to search for bad words. What they could search for is context clues. Here are the kinds of things that usually accompany racist jokes. But here's the really cool thing that they're doing that's related to that. It's this project called cartridgeization. So not only will they be training their AIs to find this sort of information, but they'll be asking experts to find it from recognized law firms. So you don't buy a tool using IBM Watson that helps you find bias within email. You buy the tool that was created by the lawyers at Smith & Jones, who are the best lawyers in the world by this. They're the ones that dedicated time to the training for it. So the opportunity here, of course, is for the firm to brand themselves and gain some of the profits off of it. But then for the community, the people that receive that product really have a value that is basically otherwise totally unrecognized. I'm not going to try to talk about blockchain because Daz will do a much better job than I am. I'll leave it to say that everyone in legal is talking about blockchain. and the opportunity that blockchain presents and the risk that it creates for disruption within the field. And the money is flooding in magic, right? So I always like to follow the money and see who's spending money on what. All of the banks are putting money into it specifically for legal solutions. Again, I'm going to pass to Daz on this because he can do a better job answering.
And by the way, just to generalize, when you say legal solutions, we're talking about things like contracts of exchange, records of relationship with customers. I mean, what is legal?
Yeah. So the financial industry, so like mutual funds and finances, is heavily sort of invested in blockchain as it relates to legal. And then let's see, property ownership, people with a deep interest in property ownership. So like creating clear title to who owns a piece of property in a way that is unassailable and won't relate there, it won't result in people having problems because a local registry for that. So this is called Christmas Butterball. For decades, people like picking under an Indian, and I always sort of am taken by images like this. There are a gazillion of them on Google. Because of course someday that walk is going to collapse. And the idea of sort of letting it collapse without thinking meaningfully about how to make a difference is the thing that sort of beats me up at night and helps me sort of get motivated to talk to folks like you about what they can do. So the challenge for regular working people is even more acute than the one for the for-profit business that are all the time. So the United States has about 7,000 legal aid. Legal aid lawyer is a job it is to represent one person in non-criminal actions when they have any. So Gideon versus Wainwright is a Supreme Court case. Everyone in the United States, citizen has a right to a lawyer to represent their interests. That's only for criminal cases. So in civil cases where jail time is not solution. You have no civil duty. So in many jurisdictions, the data shows that 80 to 90% of that goes out unrepresented, right? And that's a problem. The job of the judge is on the top. So one person lawyer and the lawyer and the other goes up without. The judge's job is to the argument, and they can make legal decisions based on it. So this challenge of creating access to the justice is one really dramatic. 100 million people die for free civil services in the United States. And every day there are people who go to courthouses and wait in line hours just for someone to tell them what form they need to fill out. Not to help them fill out the form. Not to help them ignore the form. Just to tell them what to fill out. So this problem of dealing with the access to justice was one that there have been some sort of modest solutions. One is called law for the website serves like a non-profit legal person go on self-certified. They would qualify for free legal aid, which they are a lower income person, a lower income person. And then they can fill out some forms that are generated by some volunteer. And they've done a lot of people, a couple of million people last years. The problem is that the legal aid organizations turn away more than a million people per year. So the gap gets bigger and bigger and bigger. And the reality is they have wonderful opportunities for us. And it's that they don't have fully non-profit opportunities. Like Google created solutions for people who want to $500 or have $500 spend. There's the same sort of opportunity that operates for access to justice. But they can actually afford an attorney who's $45 an hour. They can actually work for a form that's been created. So there's real opportunity in this space. I just want to sort of lead people. So I've got one more slide, and I'm going to turn it to Daz. That's the North Star. One of the really nice things about the North Star is that it will not always and has not always been the guiding star. So for the last 2,000 years, it has been always been sort of going.
But we know that the way that we're oriented hasn't happened. There's going to be a change. And of course, there's going to be changes coming to the legal too. And it's hard to predict that. It's easy to predict, but it's hard to predict legal change. So before I pause, I wanted to sort of say this with my ability. I have an idea about what's next law alarm cry, but here's what no one really knows. So, will the rules change to make it so non-lawyers can own law firms? If it does, there's going to be a lot more interest in that. We'll create a lot more interest in being efficient, being competitive entrepreneur. Will the access to justice problem become so acute that society begins to fail in a sort of more significant way than they already do? Of course, become totally unreachable to those who don't have access. If that's the reality, there's going to be a new set of solutions that have to be realized. So I leave you with a suggestion that the North Star is going to change, and we can sort of postulate on which direction it'll change in, and I invite you to do that after Des gives his talk about a couple of things that are coming.
Okay.
All right.
The iPad's not charged.
Okay, that's a problem. Apple here. Okay, that's better. Always some version of turn it off and turn it on again. So I wanted to provide a sort of smattering or some highlights of research that we're pursuing here in the ELAB, Sandy Group, Human Dynamics Group, related to law. To do some of the things that I hope could be risk for the new venture and things that you might want to think about as part of your class here, even that this model is new sources of value as a result of So one of them is maybe foreshadowed is blockchain technology. My version all the lines perfect. So you can go to any app store and download digital wallets that will create an address for you on a public blockchain, Bitcoin or Ethereum, and that address has a public defined key that's generated in the wallet. And that's how it is. You're able to use cryptography to conduct transactions in cryptocurrency like Bitcoin or Ether. Interestingly, you also use that public key for other stuff. So one of the things that we've been exploring here is extending the functionality of wallets that operate on blockchains to also enable to use the public-private key pair to digitally sign things, for example, or to encrypt things. So the reason we think that's potentially important is because right now, you could say identity is broken online. There is no identity that we have. Gabe or I don't have our own identities online, neither do you. We have identities that are stuff at law professor, MIT identity, we have identity provided by maybe by Google, our bank. We have identities from the government. But these are all accounts and identifiers that participate in domains that are owned and controlled by other entities provided to us, and that are in no sense really are ours. However, the law and our society and economy assumes that we've got agents, that we're free people in free markets, that we can sign our own contracts, that we can speak for ourselves, that that basically we are free. Everything's working in the minutes. We are not property, and we have our own voice. We have everybody basically has a platform from which to operate on our own behalf. Now that we've transitioned, or we're in the midst of transitioning to a digital age where all commerce and transactions, education, healthcare, government interaction, you name it, are occurring online. There's some opportunity, and there's also some risk we can foresee from the gap in having transitioned all the elements, the components that rely on this physical world into a digital world. Some of those are legal. One of them is identity. And so I just want to leave you with the thought for a moment, and we'll come back to it at the end, that there may be new business models and new major opportunities for very large scale sets of transactions and interactions and other novel services and products that can founded on the value proposition of providing digital identity to people that we don't normally have, but that would be handy. And so the other thing about blockchain is that it provides an opportunity to have a record of what happened. That's important in cryptocurrency for sure. It's part of the purpose of the original architecture of Bitcoin was to have a mathematically movable ledger of every transaction that occurred. Turns out that you use this distributed ledger for other purposes as well. So another big area of research has been in putting entering other information into transactions on Bitcoin and during public ledgers. So for example, the purchase or sale of a car or a promissory note or a mortgage or payment on a debt. Transactions where right now they can be very important for a company or a person in terms of creditworthiness or if there's a dispute later. But we don't always have access to the record, and the record of all of our transactions certainly aren't in a single place. Frequently, we don't even have copies of things that happen online. There's no easy way to print something you want to, or to store in a reasonable way. What would have been a receipt, basically, in the physical world. Blockchain there's very easy ways to, for example, hash a transaction and to enter that hash online and to a copy of it in a Dropbox or Google Drive, personal data source of some kind, and for that to become a public verifiable log in effect of any transaction that one would want to put there. There are empires to be built on that capability. We've never had a shared, global, distributed, almost infrastructural service bus of this type, or a capability that is a network capability for entering publicly verifiable facts. You could hire an or you could keep a server in your basement and audit the other people in a group. You also have servers that they are in sync and have the same information. You can do lots of things on that has, which are introduce a lot of float, cost, friction, and duplication, and waste, error, and fraud, and worse into systems. Perhaps there's a way to compose or refactor this property of public blockchain as no single party owns it, mathematically provable resource for establishing facts by entering the hash of a thing under the blockchain. One of the things that we've been working on is working with Congress. Well, if you click that, you'll go to U.S. House Commerce Committee collaboration that we're doing and that we're hosting at MIT.edu/blockchain. Look at opportunities to update aspects of the U.S. code, the federal statutes, to confirm that having blockchain-based signatures and evidence of transactions is valid, in case there's any doubt. And you can see some interesting discussion from some hearings that we sort of held with them, not hearings, they public forums in the House of Representatives, where we had a lot of great ideas from entrepreneurs, lawyers, and innovators on new possible, well, first of all, technical ways to do that. Microsoft had some really interesting ways, and so did other vendors, but then more to the point, on ways that you could package that as a product or a service. That'd be very potent. The main thing, so blockchain stuff is pretty new for me, maybe a year and a half old or so, really understanding it. For the most part, what we do in San is analytics, data. And the way that works in the law is somewhat exploratory, but one of the things that I've been trying to do is take big sets of legal data and apply sort of my simplified version of the researchers' statistical modeling and descriptive analytics to that stuff. So that's the first thing we did was you look at data every time the U.S. Code federal statutes was amended over the last 100 plus years, how we were finally wrangles in different sources, and then see if any changes in certain parts of the code were perhaps predictive of other parts of the code. Might it be that changes that predict changes in commercial or something like that. So we I don't know that they don't necessarily have the right data or apply the analytics correctly, but that would be one way that you could imagine taking law, which is also data, and a lot of data, and extracting the metadata to identify patterns. I can show you something about the shape of the behavior of the system, and then understand it better. Not too different from astronomy or natural sciences or bioinformatics and other folks apply to the data that is law. More down to earth, it would be using transactional data from, for example, contracts in big companies. So in-house counsel at a big company might do hundreds of thousands or tens or hundreds of thousands of contracts a year, and being able to get better at looking at say clauses, like we're doing transaction, that kind of jurisdiction. We should consider one of these three liability clauses, but not those two, because they're showing up red or yellow, and there's litigation or confusion, or for some reason maybe it's not being part of deals that go well, for example. So there may be ways to have better data-driven decision support or predictive algorithms that can be connected to transactions, so that we can use them faster, cheaper, better, and then it gets right back to what Jake was starting to do, is increasing that without manual lawyer time, and so that could be one source of savings, and it also is a source of disruption. It raises questions about other opportunities that I want to. As soon as I'm done with this slide, I want to get into one of the things Dave said, which is ways that people who don't have a license to practice law get into the game of legal services and take advantage of the capability of emerging technologies as a new modality to provide legal service without going to jail for practice of law. Somewhere in that zone, there's an opportunity for new ventures. Just skip forward. Did some crazy things with virtual reality and IAP, and it was good. So the thought experiment I would just leave you with would be this. What if say you like your name here, could create an app that made a blockchain address on just any standard consumer or small business wallet, reusable or digital signature. So you might think that's kind of a done deal. Sign can provide a digital signature. Adobe will let you make kind of manual electronic version of signature. It's not really solved issue yet. DocuSign costs are not insignificant, especially if you're pushing a lot of transactions. It's not available, and more to the point, it's coming from DocuSign. It's weird. Think about it. Signatures always came from us. You needed a pen, or seal, or a stamp. Maybe room for further innovation. You could do it with blockchain and with just using a public-private key pair to take a digital signature. Those of you that don't know what a digital signature is, will just say heard it once. That you apply a hash algorithm. How many people here know what a hash algorithm is? You don't? Okay. So it's really important and it's worth knowing and talking to people about when you're MIT who are into this.
Don't worry, no.
Say again?
That's not know or don't?
Say again?
What was the question that's not?
Well, who doesn't know?
Okay.
And then we've got 1, 2, 3, 4, 5, okay, about half. So just very quickly, it's really important. It is an algorithm that has the property that when you apply the algorithm to data, it will give you a little string, like a alphanumeric string. And if you change so much as like, even if it's a ton of data, War and Peace, it's a big book, change just a comma in that book, or just a single, add a single character or change one, we'll get a completely different string. This is really, really handy because it gives us a capability that's mathematically provable that data has not changed since the last time this hash algorithm was applied. Really, really great for codes, for contracts, for statutes, code signing, you name it. Data, just that hasn't been nothing weird, corrupting it or problems with it. So the way that, and this is used all throughout, almost like all these apps and services and systems of our lives, like really depend upon these hash algorithms. SHA-256 is the one that you might want to Google, and the open source implementations of all this stuff. If you hash a file and get this little string, and then encrypt the string with your cryptographic key, private key that I was mentioning before, that's the definition of a digital signature. Because in public-private key cryptography, the idea is there's two different keys. Anything encrypted with one can only be decrypted by the other. So you keep one private, and the other one you make very public. Maybe you put it on your profile or registry. And when you encrypt, say, a hash of a thing with your private key that only you have, and send it to an employer or a counterparty or sister, whoever, they can decrypt it with your public key, and they know, aha, it must have come from Gabe. And then they can hash the document and get the same number and say, this is exactly what came from Gabe. They can take your public key and encrypt the hash of something they're sending you and know only you can decrypt that, if that's a thing that you care about, and that you can confirm that that's the thing that you sent them. So you can actually compose these properties in different ways. You have lots of different transactional capabilities that are super handy. There's open source free software for all this stuff. What this is getting at here is what if we just, and yet what's really interesting, I think because the legal thing I just said is kind of confusing and weird. If you weren't at an MIT seminar, you probably wouldn't have suffered that entire explanation. And it's like not some people are naturally drawn towards sort of dense and then the technology part is also somewhat dense. I think between the legal and the technology density, they're just people haven't naturally evolved business models yet. There seems to be, but it's not that hard. Because once we're into the legal part and the technical part, I can tell you firsthand from looking at it like right dead on for many years, there are empires to be built here. What if every person in small business had a thing like an app or service that was theirs, with which they could sign something, like in commerce, in healthcare, there'd be SANS and the hospital stuff, and employment, across their lives. Very powerful.
Are there countries right now talking about blockchain-based voting?
Yes. And that's where you go at the bottom of the stack when you say, what can you do with commerce? What can you do in health? What can you do in education? The bottom of it, when you have a concept that there's one single person, like a live human person, exists outside the boundaries of what Google says we are, Facebook, our employer, a government agency, you get very quickly to the source of like sovereignty, the person that votes, the person that marries, the person that decides, the person who has an opinion, the person who's free. And how, like, just as a major thought experiment, like at least in the kind of post-enlightenment Western world, our whole civilization, you could say, is premised on this it's like an axiomatic that people consent to be governed, and it's from that consent that the government has legitimacy. In the digital world, by what mechanism do we consent? Where is the signature that we have that is from us, that represents us, that cannot be taken by the people we're consenting to? Consent is a two-party transaction, please. You can't consent inside of yourself. It's weird to have an employee provide meaningful consents to an employer. You really want to have an arm's length relationship to make sure that people are free to say yes or no. They have to be able to be two parties. There's no party that is us yet in the digital world. There could be. It's like maybe 10 lines of code away, and then one huge bucket of gray matter in the brain of an entrepreneur, an innovator in business such as yourselves. So the technology's there, the law is there, no change. We already had the revolution. We already have the statutes, we already have the practices, people know what it means to sign. Like, it's maybe just putting together the technical capabilities, the legal requirements and constraints, and seeing a business opportunity. So I encourage you to do that and brainstorm about it. And with that, I want to just wrap up the part where I'm yakking at you, and then I think we'd like to engage in more of a dialogue, yeah? So thank you. I would have to say, especially towards the end, I really appreciate everyone who was looking up and going, yeah, I couldn't get this. Like, it's a glint in a lot of your eyes, which is like, I feel as though I have been compensated now. You can tell Sandy, like, we did it.
Well, describe your own about. Thank you, Daza, for giving us before we bring Gail up there also. You're practicing what you're preaching. This credit union venture. Can you give us a taste of what that is?
Sure.
First the punchline and then a little bit of background.
Yep, definitely. Oh, okay, darn it. Okay, so I think we're not. Where are we? Okay, we're not live anymore. Darn it. Yeah, so this is a. Yeah, well, we're gonna have the webpage. Since 2011, I think I've been working with Sandy Pentland's group on a dream that Sandy has, which I caught the bug of. And it's this dream that personal data could be a very, very powerful source of new value by being able to look at our individual human, almost like our telemetry, and see how we are in reality, how we behave, and how we are in groups. It's like the essence of social science, computational social science, in the Sandy Pentland way. This requires that there be some legitimate basis to access people's personal data. Right now, it's creepy. Basically, is how it feels. Like it's this uncertain foundation for accessing data. It's like a swamp, and it's privacy concerns. Are legitimately worried that there may be litigation or a bad headline. We don't really have a good way to do it. So Sandy had an idea. We gotta have personal data stores, a place where we can put our data, and where we control and basically own it, like property. And so I've been working on that for a while. I came up with a good legal framework for it, and there's been good open source that he's created. We haven't had a business model for it. The private businesses that currently provide personal data services, it's not in their interest to have the individuals own it. It's a source, it's a big asset for marketing and for other purposes. Nonprofits that are into this, I know UCLU, EFF, and others, It's great, but they're really not equipped to be in a business to provide a production grade service of a personal data store. There's a lot that goes with that. Recently, about a year and a half ago, discovered as I was learning about blockchain and starting to put some apps and legal things out there, a credit union found me. Their board was interested in having them explore blockchain technology. They heard it was good for banks and businesses. And what we discovered together as we looked at use cases and potential value propositions for this technology in their context is that one of the best fits could be a traditional business of banks and credit unions, namely providing safe deposit boxes for people. So they certainly provide depository accounts where you can put fungible money, securities, and things like that. But they do loans. They also look for arbitrary personal data, your jewels or your whatever, your critical notes and so forth. So thinking is that a new kind of service could be that these personal data stores of the type Sandy came up with technically and legal frameworks that you can imagine, contractual and other frameworks, which people can be deemed to own and be able to exchange their personal data, could actually be could be deployed as a commercial service, as like a digital safe deposit box. So Digital Credit Union, which is one of the largest in the US, and several others are currently doing that now with a couple of services. The regulator believes it's covered within their existing charters and existing authorizations as a digital form of a traditional expected, in fact, service that they should provide people so that we can have a safe place to put our stuff, our important, valuable, personal, private stuff, which today is data. It's our data that we ought to own and control and be able to share when we say so, destroy it when we say so, make money on it when we say so, just like look at it and share it with 3 people if we say so. So we can do it this way. So it's Digital Credit Union. Open source is something that's trying to do that. There's 2 people, and you, and then you.
Well, so let's
But
let's
always
also
first
bring
Gabe
Gabe up to both are.
Did that answer it? Probably over-answered it, right?
Yeah.
Okay, sorry. There's a long story here. Trying to learn how to tell stories, but still calibrating. But there was a question. Can we?
Absolutely. How about it?
So this was very interesting. So yesterday we actually had a presenter who said that it might not be a good thing to own data because right now using data is actually, could be very beneficial for society in terms of health data and financial data, whatever else it is, because people can use it easily and quickly and create innovations from there. So if you actually start controlling your data and owning it, then it might create some barriers to progress and innovation and social good. Obviously, it can lead to a lot of terrible things as well. But I'm just curious what your thoughts are.
Can I just at a high level, that's a very good question. And so what we don't want is to have people lock their data up so it's even less usable than it is now. So there's different ways to further fracture this digital asset so that things are worse. The idea of having a production grade system that's offered by heavily regulated, national networks of banks at population scale is that this would be the kind of infrastructure, legal, regulatory, technical, business that can enable the scalable access to, for example, patterns and data of the type that we want for epidemiology and public health and economic census and the sort of stuff that I imagine you were talking about, without going to right now just to make a point of comparison, we would go to brokers and we get there's no way to even ask people for that data right now. They don't have it, they can't consent. And so what we have access to is like on very infirm ground to have fundamental population-wide, public good kind of analytics. And then worse yet, it's usually probabilistic. 3 different links to this person, 1 from 4 different sets, some that's stale, incorrect, all these different formats. The way to really achieve this goal is to just in a rational way refactor how we own this type of property asset into a digital format such that we have opportunities to share directly, like for science if we want to, or that we share metadata, which could absolutely be reportable. Consider now, every time you get a mortgage, under HMBA, a ton of information about that in the aggregate is reported so that we know the market. It would be no different for the rest of our data. So like you can really get the best of both worlds by giving people a way to own, control, and use their data, and get the worst of both worlds today. So that would be my high level answer. Mind you, I'm an advocate for this, so grain of salt. Max.
Just as a benchmark to this concept, I mean, one of many, but like Oracle purchased a company called Datalogics for $1.2 billion, which does something as simple as connecting offline purchase data with social media activity to see what kind of advertising activity triggered what kind of offline purchase activity. And that's like one of many examples of that, and it's like what you're talking about is the kind of thing where you as a consumer union or with your data would be able to participate in that, be licensing that data in mass. Anyway, what do you think?
Well, I think it's an interesting challenge. So I'm actually, as you guys are thinking about like a meaningful sort of high view, I'm thinking about the reality that I've experienced. And I was try to put it in perspective with an anecdote. I had an executive from MITRE Corporation to Suffolk a few years ago, and they said, "Look, we have a major grant from the World Bank. And what they're trying to do is set up a legal system in Afghanistan. The theory being that you can never have a successful economy without having effective rule of law. They don't have a court system." And they said, what we'd like to do is we'd like to test some of our theories before we go do it in a place where there's shooting going on. And we spend billions of dollars on these new courthouses and this new system. So we have this theory. What we want to do is we want to find a US community that's sort of in need of that sort of support as a way to test this in a safe environment. So they came to me and said, "I think you can hook us up with Massachusetts." So I arranged to sit down with several prominent judges in Massachusetts. And the scary reality was that Massachusetts didn't have enough data available to make this a meaningful exercise for MITRE Corporation. So this company, was trying to do this thing in one of the most sophisticated parts of the world in a very rich state, and is trying to, sort of accomplish these challenges on a much broader scale. So when I think about data, I think about, the challenge of how can we meaningfully use data involving the court system or litigants or law, and I juxtapose that with the experience of going to the Suffolk Superior Courthouse office. And if you want to get copies of something in a record, it's a 3x5 card, and they don't have a scanner, and they have a photocopier that never works. That's 25 cents a page. So, like, the data has to have some source. And as it stands now, like, our medical record field has enough problems. We're like eons behind. So, like, I'm like super interested in what it could be, and at the same time recognizing that something big has to happen for it to be meaningful far from that.
So you mentioned two really interesting case examples where specific states among the US 50 states were testing a domain in advance of the rest. Oregon with tech aids, and the Southwest founder exploiting the fact that Texas has its different kind of jurisdiction from cross-border action. So these are both tests of a legal or legal consequential thing that later scale, or might later scale in the case of Oregon. Can you comment on how, in other ways, this sort of legal testing and exploration is happening just within the 50 US states?
Love it. So, every state is entitled to make its own laws as long as they're not violative of their state constitution or the US Constitution. So within that, states can think of themselves as laboratories to try new things out, even if other states would want to try them. So some examples are Delaware, which makes it really easy for companies to incorporate and have favorable tax rates. That's a creature of state law. We have the state of South Dakota, which has made their usury laws really loose, which is to say you can charge a lot of interest for loans, which is why if you look at the back of your credit card, even if it says Visa on the front, it's Visa of South Dakota on the back. Because why? If you're late, they want to charge you a higher percentage than the other state. So being aware of the distinctions in law creates business opportunities. And actually the one that I get most excited about now, and when the blockchain work that Dazza talked about comes along, this business will sunset, is there's the work of notaries, right? Authenticating documents for people. There's one jurisdiction in the United States that allows notaries to do their work online, Virginia. And there's a federal law that says if you have a person who's an authorized notary in one state, other states have to recognize it. So the interesting thing that's happening is, if you want to notarize something, say that you want to buy a boat from someone and the registry requires that you have a notarized title before you can transmit it. Instead of physically getting a notary who puts their physical stamp on the thing and has to check your ID against your identity, Virginia has a relatively loose rule. They say, well, you can email them the material and you can send them a picture of it to go along with it, and then they can email you an electronic notarization. And because of this separate federal law, it's enforceable in all 50 states. What it means is that notaries in Virginia can make a ton of money because they can effectively do notary work 24/7 from their iPhone for people anywhere within the United States. So because states have this opportunity to create their own law, people who are savvy in this space have an opportunity to say, like, there's a legal arbitrage opportunity, right? There's something that exists within this state that I can potentially leverage for other states in a meaningful way. So it's always an opportunity. And one of the really interesting things to do with that is to get innovators together with people that work in the legal profession and ask the question outright, what's different in your state? Let me give one more sort of exciting example of that. Has anyone ever seen the ads for Jim Sokolov, personal injury attorney? Right? So let me tell you something about Jim Sokolov. Jim Sokolov is a Suffolk alum. Jim Sokolov is probably the richest lawyer in the United States. Jim Sokolov has never tried a case. He doesn't go to courtrooms. He's licensed to practice law. He has to be. He is the richest lawyer in the United States. How does he do it? Well, no one in his law firm does cases either. Jim Sokolov is in the referral fee business. So there is a law in every state that it's illegal to use runners to help a lawyer get a case. In other words, if I'm a lawyer and I do personal injury work, I can't send my minions out to scour the hospital and say, were you in a car accident? Were you in a car accident? It's unseemly. Every jurisdiction has said you can't do that. Well, what some jurisdictions have said is, if a lawyer refers a case to you, you can participate in the fee. 49 of the 50 states have a law that say you can only participate in the fee to the extent of your proportionate work on the case. So I'm a lawyer. Someone comes to me and says, can you do my divorce work? I say, I'm not a divorce lawyer. I'm going to give you to Daza. Daza is a divorce lawyer. And Daza can then say, I will pay you a referral fee for sending me that business. And because we're both lawyers, we can make that exchange. In 49 out of the 50 states, if all I do is make a phone call, I can probably pay $50 for it. In Massachusetts, it's whatever the two lawyers agree. So the traditional thing in Massachusetts is the lawyer who makes the referral takes 1/3 of 1/3. Contingent fee cases, the lawyer gets 1/3. So if you have a personal injury case, a motor vehicle accident, and you eventually collect $1 million through your lawyer, the lawyer takes $333,000, you get $666,000. But if it's come through a referral fee, the person who gave the referral takes 1/3 of that 1/3, $111,000. And in Massachusetts and Massachusetts alone, all you have to do for that fee is to make a phone call. So here's what Jim Sokolov did. He started spending tens of millions of dollars on advertising and telling people in California and Florida and Utah and every other place in the US, advertising during like Ricky Lake and advertising like at the times when people were down and out because they've been injured or home, saying, call me, Jim Sokolov. I'm the best lawyer. I make billions of dollars a year. He does. It's just what he does is he farms the cases out. And this is a legal arbitrage opportunity, right? So Jim Sokolov's law firm is Jim and a managing partner who's really more of an administrator, and then a series of paralegals. The paralegal is only meant in the loosest sense here because the paralegals he employs just go down the decision tree. When were you injured? What kind of injury was it? They take some very basic information. They say, okay, this is a gold level case. We have these partners that we sell the gold level leads to. They give us 40%. Well, this doesn't sound like a great case. This is a silver level case. We give them to second tier attorneys and we take 33%. They make, literally, they've made in the billions of dollars by doing this. They have to outlay tens of billions a year to advertise. But this is all possible because the Commonwealth of Massachusetts has said, we're going to do referral fees. So there are dramatic opportunities when innovators get together with lawyers. Lawyers on their own can be very, very uninnovative. So it's an opportunity.
So we've emphasized the U.S. in this, but perhaps there are international jurisdictions where analogous things are possible.
So the most interesting, sorry guys, I
No,
don't know if that's filibuster. So the most interesting thing that's happening overseas nowadays, at least vis-a-vis US legal services, is legal process outsourcing. So the same way that other sorts of work are outsourced to South Asia and to other places in the world, it's happening with legal services too. So actually Suffolk Law School, where I work, has the only legal process outsourcing lab at any law school in the United States. We outsource legal work for law students. So a company will come in and say, we have 20,000 non-disclosure agreements that we have to review. We don't want to pay lawyers $500 an hour to do it. We could send it to the Philippines and pay folks there $4 an hour and hire a US educated lawyer to supervise those folks. Or we can hire your law students to do it for $20 an hour. The client will feel good about it. We'll have the same kind of person overseeing that sort of work, and we'll get it done for a lower cost for the client. So legal process or outsourcing is a real thing vis-a-vis US. So you can send your US legal work overseas, and then you have a US lawyer oversee the work of native fluent English speakers in foreign countries. The other thing that's just interesting in terms of overseas legal markets are that the US is the most far behind in terms of non-lawyer ownership of law firms. So in England, anyone can own a law firm, and there's a big firm called Slater & Gordon, which has 2,500 lawyers, and they have all sorts of investment firms, venture capital. They're publicly traded, and they have this dramatic incentive to innovate simply because they're a for-profit business that's trying to buy and sell shares for the long term. They've had some problems in recent years because they've overextended. They have a very interesting project where they go into a place called Tesco, which, as I gather, is like Target. I've never been to a Tesco. But they have kiosks there, so you can go to Tesco and you can get your food and you can get legal advice. So there's some really, really interesting thing happening with sort of common law countries in terms of how they're dealing with law firm innovation. They're just leagues beyond us. And it's an interesting sort of lab to see what might work.
So a couple of other quick things on the legal arbitrage and other aspects of what Gabe was just saying. So one thing to pull from the experience in Great Britain is, first of all, well, thinking like Massachusetts and American businesses, it's a big world. You can start a business in Great Britain and compete with this company without being a lawyer. So they're a harbinger. We haven't seen that legal reform in the United States or the rest of Europe yet. It's coming. But right now there is one particular jurisdiction, English speaking, it's not done business there. It's available. So it's like the light is just coming over the horizon at last in terms of a competitive market, types of forces, into what is previously more like a guild-like, almost monopolistic system, which is pros and cons. Some of the cons are obvious. There are pros as well. That I like this. Is where if any of you do end up in a business like this or just start one on your own, it's important to remember that the law isn't any kind of service. It also defends people's fundamental liberties and rights and basically civic systems. And so it's critical to not have a total race to the bottom and sort of like a sweat shop of some type where there's no longer any incentive or capability to defend the rights of people going to jail or the travel bans and all the rest of it. So like there's multiple purposes of law. It's not all based upon market forces. However, getting a little bit of market force up in here would be really helpful. The second thing is, what can I say about market? What market? We barely, as I learned what markets were in undergraduate, basically school, there was the capability of people with demand and supply to find one another to negotiate on some good or service. Right. So I want to identify something happening in California with a friend of mine in a program called Tony Lai. He has an innovative business here called legal.io, where what he's trying to do out of a Stanford Codex thing is create a digital marketplace for legal services, wherein legal service providers, primarily lawyers, but some non-lawyers that are doing contracts and things are allowed to do, can hang on a shingle, and people that need legal services can create an account and search and find one another. And then the most important thing he told me, which is when we became like an advisor to his company, because I knew this is different and it's been missing, is that I said, well, what do they search for? Is like a word search? How do you match people? How do you know what they need? And he said, oh, well, like it kind of, we're starting with, I think, 16 or 20 types of matters. So there's like a eviction in San Francisco, there's like a no-fault divorce, there's a divorce with some contention of custody, and they have like these like 3 or 4 flavors of 3 or 4 types of like startup with a trademark and with a convertible note or not. And then basically he said, and so we call those packages. And now if you provide that package, you can describe the package. And if other lawyers provide that package, they can just point to this object in our system with that package. And I thought, oh my, what's been missing? We haven't had a concept of a product that is understandable across more than one provider. A marketplace that allows for supply to find demand and to set a price and begin to benchmark. Is this an amazing? Is this airfare, or is it airfare on my own private jet, or is it like a helicopter ride in the
So
back?
it's Alibaba for legal services.
In effect, it's Alibaba for legal services. So consider you could do this as well.
One sort of bizarre, perhaps will happen more frequently phenomenon in the modern era, is that people who are innovators, think Uber, are not looking at the law and seeking open opportunities, but instead saying, no, the law is wrong, we will operate and fight it out, either in the court of public opinion or the court of legislature or the court of courts. And this is very different from how you articulated things at the beginning, where people were arbitraging or looking at the law and reading opportunities into it that people previously hadn't. Can you comment on this approach to basically violate or to win?
The few companies and the few entities that have entered this space with services aimed at consumers, which are what are going to create tension. So there's no tension for companies that are coming in and aiming to service law firms and law departments at corporations. There's just no tension there. But when someone comes in and they do something that's going to potentially take business away, they're getting sued. And what they're doing is taking what I hate to be sort of a startup mindset of saying, like, we're going to do this, stop us. So like the Airbnb thing, like whenever this taxi cab commission wants to sue us, whenever the judge bangs, like, yeah, well, I guess we'll stop then. But until that time, we're going to keep doing this thing. So it's like LegalZoom, which is, again, the best example because they're the biggest one in the space, is they've waited until they got sued, and then at the last minute, they've entered a consent decree that hasn't damaged their core business model. What it's done is they've agreed to provide an additional service or make a gateway to an additional service that would bring the lawyer skill back into things. So part of the reason that they're able to do that is because, you know, companies like LegalZoom and Rocket Lawyer, which is their main competitor, are well funded. So LegalZoom got, when they pulled their IPO, they got $200 million from a private equity firm. Rocket Lawyer, which again is LegalZoom's main competitor, but not on par with them, got $25 million from Google Ventures. So they're able to litigate and to take it to the mat. So far, they've been largely successful.
What about permissionless innovation? It just, I guess it almost, yeah, so it's something that Joey Ito is a really great proponent of, and it's refreshing, and it speaks directly to the law, in part, is the importance of when you have a new idea of honestly a better way to provide transport and scale than the taxi cab medallion service, such as Uber, using an app. You know, the way not to not do it in general, this is like not what I learned at Suffolk Law School, where I went also. You don't start by legal analysis and then, you know, like conform and contort your business to the tax and the local regulations and everything, but rather in a bolder way, more pioneering way, put it out there in view of the law, but not necessarily resolving all legal issues first, and permissionlessly seek or forgiveness for like negotiate things later. Now, obviously, you can blow up if you end up in jail, and if you push that too far, you'll be bankrupt and, you know, and sued and the rest of it. But there's a gray zone where mature evaluation is appropriate, and it's one that Joey and many people, Jonathan Askin, who was here last semester and spoke to this class, law professor, and others, they advocate being less conservative with legal analysis up front, and then more more innovative on that, and then fighting it out later. I have to add, that's one of the ways the laws evolves as well, through that type of healthy tension. Permissionless innovation with a good lawyer is terrific.
Well, final few questions from, yeah, go ahead. Group call.
So you mentioned about personal data stores. So the question was the way we generate our own data is through interacting with entities or other individuals. And so how do you imagine this data store to be built up in terms of aggregating these data? And will these data stores have the raw data itself or something like agile algorithms that you were mentioning? And then there are certain legal challenges also in terms of validating those data that the individual is owning. So
What's your name?
Rona?
Rona?
Yeah.
Okay, those are real good questions. I want to talk to you after class.
Yeah.
And so real quickly, in order, first of all, it's the way that we imagine that the best way to get all the data is as you're going through transactions, setting up feeds and triggers so that you get a copy of the stuff in real time. So when you click to agree, you just get a copy of it. Like JavaScript can do that a lot of the time. Number two, because Sandy's been pushing this idea, and I was forced to research it closely under HIPAA for healthcare, Fair Credit Reporting Act, the Federal Privacy Act for government stuff. The big one is telecom and others. We have a right to actually request a copy of data that relates to us, and companies under these legal regimes have to tell us they have data and then give us a copy. That's interesting. So I mean, that's a great way to populate one's data store with authoritative data. And then finally, you said, how do you know if it's accurate? That's really important. And so hashing everything I said there will tell you it hasn't changed, but you don't know if it was accurate when it changed, when you first had it or whatever. And so there's a whole emerging new marketplace for different flavors of verified claims, verified attributes, confirmable assertions, attestation, by many names. But fundamentally, what it comes down to is that digital signature thing I was mentioning. Whomever the authoritative source of something is, MIT with respect to a diploma, for example, or a professional certificate, an employer in terms of verification of employment, insurer in terms of verification of insurance, and so on. The government for license to drive can actually digitally sign an attestation that this person, for example, with a public key or an address or what have you, has this attribute. Copy of that in your data store, and Bob's your uncle, like you were good to go. Start accumulating those, they're verifiable at the source through like a REST API or something like that is what we imagine, or however you verify it, or just look at the key, just you decrypt it with the key that's associated with that party on a blockchain address or a key server or whatever. This is how you can begin to get fidelity in terms of the validity and the truthiness of the assertion. Okay, good questions. Yeah, yes. I think you should call because that's your professor. Please.
Yeah. I'm very interested in hearing your thoughts on the ownership of the blockchain, specifically within the legal context. Because they're having a lot of discussion on who controls blockchain, and I was reading an article from yesterday. Basically, they're arguing in order to incorporate blockchain into the other industries or to use the application, we have to really accept the rule of blockchain, which is a decentralized system that no one controls itself. I'm just wondering from your perspective, what are your thoughts on that?
Please.
I didn't understand the question. I'm sorry.
Like who controls the blockchain?
Oh, okay.
They are trying to use it.
Can I take interest from that? Okay.
Yeah.
So part of what's so weird about this, and I think I finally understand it technically, but I don't know what I'm looking at exactly, is nobody does control or own this. So I'm fairly familiar with any other system like this. I don't know if I am, and because I won't go through all the math. If you want to track through, I don't mind sharing with you what I learned. But it's decentralized in a way where there's not a party you could sue. There's no address. There's not a discoverable owner of the system writ large. What are you thinking?
Just a follow-up question. So for the blockchain technology itself, no one controls it, but specifically in the legal context, under political pressure or regulatory pressure, do you think the system can still
Oh, I
stay
got you.
decentralized?
No,
Or do you think
I do
there-
not.
Okay.
And so there's layers of the system, and it's a stack. Today, you can go and grab the data. It's easy. You don't even have to break into a secure facility and grab servers. It's just distributed everywhere. And you can do signals analysis more or less, or other types of forensic analysis of the transactions very frequently with a little bit of other data from the web to identify the endpoint. So like, a bunch of transactions coming from a single mobile phone, for example, just the way we do today with, surveillance and with marketing stuff. And then you can start connecting blockchain transactions to individual people that you can then extradite or sue or whatever. So, mind you, like it's not really magic anonymity. The data is available. What's different? One of the things that is very different, however, is that if you really take care and you use Tor and other stuff, you could obfuscate identity if you want to. It doesn't do that out of the box. But the important thing is that there's not one point of failure. You can go to Google and take it down, or you could go to whatever, like this government or this place and put a backdoor in or anything like that. There's no single control point or choke point. That's interesting.
All right, one final question, Max.
Thank you. In talking with people considering legal startups and like legal tech startups, one of the things that comes up early is this question of the team and kind of who you need on your team, and not just like the really active day-to-day co-founder types, but like advisory and potentially like partners, and potentially partnering big with an initial firm, and does that firm have a stake, and so on and so on and so on. But just in terms of that composition, and maybe if people are thinking about startups, like that question of if, as you've seen companies form, like what kind of thoughts do you have on what's working, what's a dangerous route, or any?
Yeah, so the most common combination I've seen is an MBA person, usually a recent grad, together with a legally trained person. So often it is a legally trained person who comes home and tells her partner, this really irritating thing is happening at work, and the MBA person says, well, wait a minute, I think we might have a solution, and they go off and they create something. It's becoming easier and easier for legal startup founders to get buy-in from law firms, and there are two law firms I can think of offhand. One is Denton's, and the other is in Colorado, and I can follow up with you on the name. That both have in-house, they call them incubators, but they're really testing centers. So they say, look, we'll support you in the creation of this, and we'll be a use case so that we can help you with a beta version of it, and we can provide data feedback, and to the extent that it's a valuable thing that you want to bring to market, we can be your first example of a success story. So, and then there's in Toronto, of all places, there's a really, really lively legal tech startup scene. There's a company called LawMade, which is basically supporting that sort of thing, like early startup legal tech teams and helping them build up their team in a way that will be useful.
There's legal incubators, legal hackers is a huge chapter up there. It's off the hook in Toronto.
Plus the Seton Legal Hackathon effort you run. I mean, that's an intriguing place to look at exploratory new ideas and people, right? Who shows up at a thing like that? It's this interesting mix.
Yeah, and it's legal, business, and technical at the hackathons, and sometimes some of the best of these combinations I've seen just anecdotally, I haven't done a study, has been people that like to hang out with each other, have an idea, and it somehow happened at the same time where they kind of caught the bug, and they hacked on it, just rolled up their sleeves with a whiteboard, and like, so these legal hackathons are, I've seen several startups come out of them. I strongly recommend everyone go to hackathons, generally, well, especially when you're at MIT, but try a legal hackathon and see what happens.
But if you were like an entrepreneur, maybe would you say recent law grad student or somebody that's been in the field longer?
Practitioners are great because they're the ones that bear the scars, right? So law students don't know anything about the real world. Law school is very divorced from the practice of law, but if you just find someone that's kicked around a lot of partner in a law firm for a couple of years, and ask them the question like, "What's the worst part of your job?" You're going to get some really interesting responses. Actually, someone on Reddit a few years ago asked that question, like, "What's the worst part of law practice?" You would believe the stuff that came out. I mean, business idea after business idea. Yeah, as well as a lot of psychological.
Well, everybody, join me in thanking. This example, picking a lawyer who's got experience or not, turns out
One of my favorite examples of 100K winners was a Harvard Law student, Gary Cullis, who prior to taking on formal degree studies, I've been a patent agent, which is not lawyer, but frustrated with what it took to search through patents and particular citations. So could we do better with computation? And he ended up, as a Harvard Law student, entering MIT's competition, linking up with a CS student here to do search technology. Ultimately, brought in MBA as third member of the team, founded Direct Hit, which ultimately sold itself for $500 million to Ask G, so it's now the underlying engine behind Ask. Right? It's rival to Google, roughly same vintage, actually a little bit older. But it's not Google scale venture, right? It's not a $250 billion company, it's really a $500 million company. But among friends, what's a few orders of magnitude once you get to $100 million, right? Yes. So I wanted to just give you that as a case example, why from this place, this environment we're in, the Harvard, MIT, Greater Boston Metro, Suffolk, Northeastern community of prior legal venture. So this is a good super theme to be discussing. To just signal what's happening next week, our penultimate class, an alumco from here, a neuroscientist, Carl Marcy, connected with an MBA student, Brian Levine. Brian has been in the ad tech world and frustrated with the inability of traditional methods of understanding what consumers are thinking. Thought perhaps there's a neuroscience dimension that can be added. Those two had at it, founded Interscope as a consequence of their media ventures activity. Ediscovery used neurometric tools to better understand people's emotional reaction to media, to advertisements, to imagery, to stories, whatever. That, fast forward, was bought by Nielsen years ago, and now forms the core of Nielsen Neuroscience. And Carl Marcy, who co-founded this, is going to be in class next week to share with you all what it means to better understand consumers, consumer sentiment, ads, the works. And that'll be our final, penultimate sort of tech injection showcase of how new technologies have changed the landscape for media venture opportunities. So that should be good. That's coming up next. And then in 2 weeks, that's it. The 18th. On the deliverables, and plus in class, what we want all of you to do is very much like you did with idea pitches. Put up on a screen that sums up where you started, what you've done, and where you think this might go in the future. Just like in the beginning, we want to collect all those before class, so we show it with one laptop. But everybody will get a chance to share as teams what you did this semester with one another. So this should be a fun sort of summary experience. So it's a roadmap, analysis, adventure. And yeah, we're looking forward to that and to everybody's final stuff. See you all next week, if not earlier, during office hours. And thank you again.
Do you have time to connect next week?
Next week. Or even this week.
Next week.
Yeah,
One of the things about that, I was talking about
So, you know,
So anyway, let's say I write which I I think that's not working. I think what's better would be like you if I should get
All you're doing is scraping MLF. So the automated closing documents is accomplished through software, DML. That's exactly what it's right. TurboTax is do that. But the computing power, just asking serious questions, copying down the number of variables, publishing. Any lawyer can do it. I mean, it's so people that do that work in their mind, they're working like meeting all because with that, sometimes there's sort of strategic work, but the residential real estate is you're closing documents, or the mortgage documents, closing documents. There's reform. So it would be valuable for country which is licensed and they would be you want to capture that. So wait, so would your customer be a real estate business or using your the whole shebang?
Right, it's not gonna end in 2 weeks. Right. Well, just getting ready for actually everyone's getting very much. This week, so like that's my life right now. It's just like, yeah, that's the scary part.
I mean, if I were you, I would think of how to
kind of hard-based engagement. Yeah. The other guy
Modulate your levels of detail and recursive side calls.
Yeah.
In other words, you tend to.
Really helpful.
Yes. I get it. Completeness. But it's say crediting is not only remember save money and loaning, getting a loan, but they have an interesting historical concept. Imagine credit digital assets. That's an interesting thought. It turns out in engaging with personal data store has the consequences investment business for that. This is each that is some punchline for so this is an example. Punchline for too many persons. It's good. That's a detailed question. No, most people don't care.
Right.
But that's his problem. It's too easy.
So he's into it. Modulate more questions that one.
Sometimes questions like that are not easy. So it doesn't say what the second class.
Yeah.
The big picture is everybody. That's modulation. And then incursion. It's kind of failure. And oh, by the way,
that's why
It's like this. It's like easy.
Caveats, provisos, clauses, and subclauses. So that, and also, I don't know, but when you present your fairness score, you need to get somebody to get into this sort of yeah, talking about stuff for slow, share well, watch.
No, I know that. I just didn't know that we should be faster. So that's why I can slow.
Right. So it's a great overall.
So also compare yourself to yourself at the beginning of the page. And like yourself later. Literally.
I do. We just a lot of bad choices. Yeah.
And then, you know, one thing the story that tells I would do my administration. Well, so for example, you mentioned last Jonathan. So it was a story. We're not lawyers. So for instance, before the whole Skype, faculty comments. Went through the arduous process of trying to do a Skype legally. And they waited so long and pushed so hard to change the law that Skype just did it and ended up running it. That's a story.
That's a story.
I think it has nothing to do with he's a lawyer. And he's not a lawyer. So there's Skype now. They broke all the laws. Telecom laws.
And the guy seeking permission, one page.
Which is the universe example of what's playing out with Airbnb. That's what makes it an interesting story.
Hey, can we ask you a straight up question? What's a good way to, I did Toastmasters in the day and it was okay. Where do I learn to just scrape all the particles from my bad speaking habits and get back to being a good speaker? Like
One of my friend's son said, "You're boring."
I'm not boring now.
And you know, what do you mean? He said, "You know how to tell a story. You just go on and bullshit. Get to the point."
Dude, I bet some footage of you in Handle Square yesterday, standing up in front of this big crowd, like waving your hands, and everyone's like rapid attention. I was going into the post office, like, oh, it's plastic. Sorry.
No, sorry.
It's yeah, but I don't. That's you know, it's not an answer. That's it has to be.
And also, I was really embarrassed. Everybody in the 100 10 to 50. There's yours truly mumbling. I had a card that had all my points, and I got the card. You know, I mean, it's a disaster, right? So it's so
The crucible involved you.
the crucible that kicks my ass.
Maybe you gotta
I mean, you know, you could.
now we couldn't
No, it was really bad.
Hi, thank you for your class today. This is the
Oh,
he's done.
Well, I'm gonna get on.
Okay.
When
This would be very sweet.
Come by and-
Can you just use some of the two problems?
Yeah, although this coming Wednesday I have,
Oh, what day would you
maybe I should come by.
Okay.
Well, Wednesdays will typically be as long as.
Did. Before I changed something, and just let me know.
I'm sure, you know, if you can carve out the hours.
But yeah, that's what you can forward to. Kind of here hanging out. I think it's entirely well done. That's very
I know, it's a thing, I feel like he's such a good social.
That's not true. I look forward to it.
Yeah, you should. So,
Right, so that is- that is what I.
I'll bring you coffee.
And then,
So I will, let's talk this week.
Okay.
Yeah, I would love that, you know, right. I think so too. Like, it was great, like, I feel like this was very good introduction to what I consider like, you know,
Take this first one instead of saying
it's distracted.
yeah, we actually really like it.
So I think like there's really no further anything we need to learn, go for it. Whereas I'm concerned, trouble, what the trouble is. We could take it easy. I don't think so. I do.
I'll see you soon.
Yes. Appreciate it. Look forward to it.
Thanks.
Follow on.
Yeah, let's throw some trouble.